I'm sitting in the midst of eminent persons, so I don't have capacity to talk about marriages and relationships, but I'm going to talk about it from a legal perspective. When I opened my law firm 3 years ago, my first case was a divorce case, and I was acting for the respondent, so I was defending the man.
Rosemary is clapping.
That's what you don't get to choose. Yeah. So all I can say actually comes from the legal perspective. And Article 45 of the Constitution is the one that forms the basis for family, and it talks about family being the social and fundamental unit of the society. And goes further to talk about that parties in a marriage, rather in a family, have equal rights and protection from the state. Therefore, it invites Parliament to enact legislation to secure those rights and rights and those freedoms of married partners. And that's why Parliament has a Marriage Act, has enacted Marriage Act 2014. It has enacted Matrimonial Property Act 2012, I believe. 2012 or 2013, I am not sure on that. So on Marriage Act 2014, it establishes the different forms of marriages that we have: Christian, civil, Hindu, customary, and then it goes further to spell how can you walk out of a marriage, and it says it talks about cruelty, desertion. It talks about marriage irretrievably breaking down. Those are the factors, some of the factors that you have to challenge at it. Some of the factors that you can petition divorce from.
Yes.
What the bill is introducing actually is it's not about marriage irretrievably breaking down, because that has always been there. What the bill is introducing is divorce by collusion, saying that two partners are deciding that this thing cannot work, and so they are coming out to tell the court this thing cannot work. Because as of now, you cannot come together and say we've consented to divorce. That is illegal. Actually, it will be seen as collusion. So divorce by collusion.
Is that what the act essentially says?
That's what the bill is introducing.
That you can't go to court and say we've decided to.
But now you can come to court and say party A and party B, we've decided to call this quits.
Yes.
And then the court is going to grant you your wishes and grant you divorce, because the court actually does not really promote divorce, because divorce is actually two-tied. When you petition court, you'll get decree nisi and decree absolute. Decree nisi is the first decree that you get after petitioning for divorce, and you're given 2 months to go and make your decision, to go and make up your mind whether you still want to do this divorce. If you want, then you come back and get the decree absolute. But even before you get it to decree nisi, you'll first be told to go for mediation. So the courts and even the law itself does not really open the door for you to come and get divorce. It makes it so hard. That's why it has been almost impossible for you to prove things like marital rape, for instance. It's not a condition for getting divorce in Kenya, but for Hindus it is. But for customary Christian civil marriages, you cannot go to court and say there was marital rape, for instance. Yes. So those are hardliners that the law has kept, so that it has made it sure that marriage as an entity or marriage as an institution has been protected by the law. So I don't see it from a point that the law makes it easy. Even when you say the marriage has irretrievably broken down, there are a lot of factors you have to prove. How has it irretrievably broken down? How have we gotten to a point where the two of you cannot work out together? And it's how you have to prove that for 2 years he's been cruel, or there was adultery, or desertion, he has gone ahead and procured another marriage. So for me, where I sit, I don't see the law as it is being that flexible insofar as getting divorce.
I'll be coming to you on